Greetings, Attorney Derek DeBrosse here, Munitions Group, munitionsgroup.com. Look us up, subscribe to our channel, go ahead and like us on social media, and continue to follow us. Drop questions in the comment box so that we can try to put it in the queue and get some answers to you guys. Today, as I promised, I'm continuing with my restoration series. I'm going to dive a little bit more into felons. I'm not going to complete it today. I'm not going to go over the case law today. I'm going to do that in another episode where I actually dive into the citations and kind of go through what each court says. But I want to go over kind of just the framework of how this all kind of functions together before we go over those cases that kind of break it apart and say this is why it functions this way, because it can be relatively confusing. So remember, there's 9 disabilities under federal law, and today we're going to talk about what we call the G1 disability. So again, the Gun Control Act of 1968 is codified under 18 U.S.C. 921 at sequence, specifically 922 subsection G, are our list of disabilities for gun ownership as well as ammunition ownership. There's some exceptions we'll talk about another episode where it doesn't apply to antique firearms, black powder firearms. It only applies to commonly discoverable ammunition, things like that. But we'll deal with all that another day. So let's just focus on the disability, and then we'll go from there. So the G1 disability, what it actually states, and I'm going to read it to you verbatim, so we're all on the same page. Anybody who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. So let's break that apart for a minute, because it doesn't mean exactly what it says on its face. When you read it on its face, you're thinking, well, any crime, it could be a misdemeanor, it could be a felony. Well, as you'll see, it only applies to some misdemeanors. Most it doesn't apply to. In Ohio, it applies to none, this specific disability. But in some states, it could apply to misdemeanors. So somebody who's got to be convicted, it's got to be an actual conviction. So a lot of times what it calls, hey, I did a deferred adjudication where I pled guilty, they didn't find me guilty, I wasn't convicted, I went out and did community service and they dismissed the case. Generally that would work for not losing your gun rights because you were never actually convicted. It's got to be a conviction. Juvenile adjudications, depending on the state, for instance, where I'm located in Ohio, a juvenile adjudication is not considered a conviction. It's considered an adjudication. We treat juveniles very differently than we treat adults because they're essentially, the theory is that their brains aren't fully formed and they're not as culpable for their behavior as are adults. So it's got to be in a conviction, generally speaking, an adult conviction. It's got to be in any court, so there's due process attached. And it's for a crime punishable by imprisonment. So punishable, not that you were punished, not that your sentencing said that you did this much time or you're sentenced to this much time. The way I describe it to potential clients, because this can kind of trip them up. They're like, oh no, I was only sentenced to a year and only served 6 months. Well, what could the judge have sentenced you to? And what I tell clients is, if they threw the book at you, what is that book, right? Does it exceed a year or does it not exceed a year? Because most times, almost every time, the judge never throws the book at a defendant. They're never sentencing them to the full potential sentence they could be sentenced to. And it's for a term exceeding 1 year. Not 1 year, but exceeding 1 year. So a year and a day. So keep that in mind. A good example of how that kind of comes into play in Ohio, we have felony 1 through 5, 5 being the lowest, and that's only punishable by exactly 1 year. So it actually falls a day short. So in Ohio, you can be a felon and possess a gun under federal law if it's an F5. Now in Ohio, the felons that we take away gun rights from are drug-related and violent-related. So as long as it's a non-violent, non-drug-related felony of the 5th degree in Ohio, you should be able to possess a firearm because you don't have a federal disability, because it's not punishable by a term exceeding 1 year. F5 is only punishable by exactly 1 year. It's not violent and it's not drug-related. Therefore, Ohio's disability doesn't attach. So within Ohio, an F5 felon under federal and state law could possess a gun. So just understand that. 18 U.S.C. 921, subsection A20, defines the term crime punishable by imprisonment for a term exceeding 1 year. Yes, only lawyers have to explain what something that on its face seems to make sense, what that actually means, right? Yes, it doesn't mean exactly what it says, and this is what it goes on to say. It does not include, A, any federal or state offenses pertaining to antitrust violations, unfair trade practices, restraints of trade, and other similar offenses relating to the regulation of business practices. I'm not going to jump into that a lot today. I'll try to get to that in another episode. But basically, from my experience, I've never had an individual client who's ever been convicted of these. Generally, I think it's going to be more of a corporate conviction of a company. Not that it's not possible for an individual to be convicted of these, but I have not seen it come across my desk. Most people that are convicted of financial crimes at the federal level that I've experienced actually are pled out or convicted of mail fraud of all things. And then that does not qualify. I've found case law on that. But I want to get to what's really important here, and that's B, any state offense classified by the laws of the state as a misdemeanor and punishable by a term of imprisonment of 2 years or less. So when it says a crime punishable by a term exceeding 1 year, what that means is felony. So a felony over a year or a misdemeanor over 2 years. In Ohio, the most you can do for the most heinous misdemeanor possible is I believe it's exactly 6 months. We have something just called a misdemeanor, and it's not what we call an unclassified misdemeanor. That may be punishable up to a year, but I can't recall. But in any event, we have no misdemeanors that are punishable, to my knowledge, of over 2 years. Not 2 years, but over 2 years. Some states, I believe Pennsylvania is one of those states, you can do maybe upwards of 5 years for certain misdemeanors. So keep that in mind if you're ever in a bad spot and you're asking your attorney if you have gun rights, if you took a plea, just make sure you ask them, what's the maximum time I could possibly do? Worst case scenario. And if it's a misdemeanor over 2 years, then that should give you pause, or a felony over 1 year, that should give you pause. So that is the definitions section of what it means to be convicted of a crime punishable by more than 1 year. So let's say you have a felony for, let's just call it drug trafficking, felony 4th degree. You're convicted of 4th degree felony. You want your gun rights back. What do you do? And that's what we're going to talk about a little bit today. So with that said, there's a lot of case law, and I got a list of those cases. Let's rattle them off real quick here. We will be covering most of these cases in a later episode. But Beecham versus United States, Binderup versus Holder, Suarez versus Holder, U.S. v. Clegg, Caron versus United States, U.S. v. Cassidy, Caron and Cassidy, Caron, Cassidy. Those two cases, Caron and Cassidy, are probably the two most important cases when it comes to understanding this concept. So we'll go over those. Logan versus United States, more important in domestic violence. U.S. v. Boast, U.S. v. Burns, U.S. v. Chenoweth, et cetera, et cetera. We'll go over all these another day. So what we look at when we're talking about restoration, we're still operating within that definition section. There's another clause to it. I'm going to read that to you. What constitutes a conviction of such a crime shall be determined in accordance with the law of the jurisdiction the proceedings were held. Any conviction which has been expunged or set aside, or for which a person has been pardoned or has had his civil rights restored, shall not be considered a conviction for purposes of this chapter unless such pardon, expungement, or restoration of rights expressly provides that the person may not ship, transport, possess, or receive firearms. Complicated. It's a lot to unpack, so let's go through this one phrase at a time. What constitutes a conviction of such a crime shall be determined in accordance with the laws of the jurisdiction with the proceedings were held. So I had another attorney once approach me. He was a young attorney. We were litigating. He was such a bad lawyer, too. I'm not going to name names, of course. We got sanctions against him because he just wasn't doing his job properly. But in any event, I remember we were talking in my office once after a deposition. He said, "Hey, I heard you do gun law. I just got a guy his gun rights back." And I said, "Oh, really? How'd you do?" He said, "Well, I expunged it in Ohio." I'm like, "Well, what state was it from?" He's like, "Oh, it was a federal conviction." So you guys know, in Ohio, we have the ability to expunge or seal records that are not within Ohio's jurisdiction, but for Ohio purposes, you can still seal or expunge them in the state of Ohio. So I told him, that doesn't work. That doesn't work for federal purposes, and he didn't seem to be too keen on me telling him that, but I had to explain to him, you just advise your client to commit a federal crime, because even though you have a quote-unquote expungement from Ohio, it doesn't work for a variety of reasons. One is what we're talking about right now. You have to fix it where it occurred. If it's a federal conviction, even in Ohio, you have to fix it in federal court. And generally, there's no way to fix it at the federal level other than a presidential pardon. And that's a different discussion for a different day. But, we don't have expungement at the federal level. Set-asides don't exist at the federal level. And restoration of rights is just not funded. There is a process in Ohio, under federal law under the Gun Control Act, to restore people to their gun rights, but what Congress routinely does is just not provide funding in the budget bills every year, so they don't hear the application. So that leaves one last option, and that's to do a pardon and get that from the president. So generally speaking, not fixable under federal. So this person, at the time in Ohio, we didn't have expungement. We called it that, but it was just sealing the record. So first reason, his plan of attack for his client didn't work is, one, it wasn't expunged, it was sealed. It's not the same thing. It's got to be a complete obliteration of the record. And then two, it wasn't done in the right jurisdiction. You have to remove that conviction because it's determined in accordance with the law of the jurisdiction where the proceedings were held. The federal government will look at Ohio's expungement or sealing and say it doesn't matter. We still think it's a conviction. So that's the first part of this restoration clause. Second, any conviction which has been expunged, set aside, pardoned, civil rights restored shall not be considered a conviction. So I'm going to cut this clause in half and stop right there. So again, there's 4 ways to get your gun rights back on its face at the federal level. The first is through an expungement. It's got to be an actual expungement. It cannot be a sealing of the record. It's a complete obliteration of the record. 2, a set aside. So this is a set aside of a conviction, typically used for people that are on death row or wrongfully convicted people. I've done a lot of these in Ohio for just such purposes, and we've also done them for domestic violent offenders because there's really no other way to fix a domestic violence disability in Ohio. It's a set aside. And it's very difficult to win. Normally you have to prove some sort of constitutional defect in the proceedings, which rarely happens. Or for which a person has been pardoned. That speaks for itself. The pardon must come from the jurisdiction in where you were convicted to relieve that disability. So if you have a Ohio conviction, you need a gubernatorial pardon from the governor, not from the president. Or has had their civil rights restored. And let me kind of jump back to the issue with the jurisdiction. So we had a client recently that lives in Georgia, runs his business in Georgia, was traveling to Ohio on business years ago, got convicted of a low-level felony, and we got it expunged here in Ohio. His gun rights are intact federally and for Ohio purposes, but not every state recognizes that. So we have to look at the other states' laws, and where he lived in Georgia, there was nothing, at least nothing clear that said they would recognize what Ohio had done, and in my opinion, they could still hold him to have been convicted of this crime. But in Georgia, they have a specific process through the Pardons Office, Pardon and Parole Board, for restoration of gun rights alone. So we're going to be putting them through that process. So once you get your gun rights back in the jurisdiction the proceedings arose, if you live in another state, you still have to deal with the state that you live in, and they may or may not recognize it. I know Florida recognizes out-of-state restorations. Washington State, in many instances, will if there's a finding of rehabilitation in the process. So it just depends on the state. And Tennessee has their own process that they require. And I just did a big research project for a client where we went over like 15 different states to determine if they'd recognize a restoration order in Ohio. All right, so again, it's determined in accordance with the laws of the jurisdiction the proceedings were held. There's 4 ways to get your rights back: expungement, not sealing, but expungement; a set aside; a pardon, which statistically in most states is relatively not happening. It's just not. I think last I looked in Ohio was under 2% are granted. And then lastly, have their civil rights restored. So in Ohio, we have a specific process for that. But what you need to do, depending on where your conviction is at, look at the state and say, do they have a restoration of rights process? And what we're actually looking at when we talk about restoration rights, and this comes from one of the case laws, I believe it's the Cassidy case, we're not looking at gun rights. We're actually looking at the rights pertinent to citizenship. So what we're looking at is, have you lost your rights, and can you restore those rights? Because you can't restore something not lost. This is where it becomes problematic for restoration for misdemeanor crimes of domestic violence. Most misdemeanors don't lose their civil rights. They lose their gun rights, but not their other civil rights. So you can't restore something not lost. So the way the law works, we're talking about restoration, is 1, you have to first lose your right to hold office, serve in a jury, and vote. Those are your 3 rights pertinent to citizenship. If you lose those rights, then you look to the state where you were convicted, the jurisdiction of the proceedings arose, and say, have they been restored automatically, or do we have to do something affirmatively to restore those rights? And once they're restored, is there any restriction on gun rights at all, concealed carry or otherwise? So it doesn't have to be just possession. It's anything regarding guns. So again, restoration must be more than just that, a single right? So if there's a process where, let's say in Kentucky, you automatically, upon finishing what we call getting off paper, getting off parole or probation, once you're complete with your sentence, sometimes states will say, well, you can vote and hold office, but you can't serve in a jury. Well, it's not a full restoration. It's got to be those 3 rights. Let's see here. So we'll take Ohio as an example, kind of the process and how it works in Ohio, but every state's going to be different. Remember that. So in Ohio, once you're off paper, there is 2 different statutes in the revised code. They don't talk about guns, but they talk about your right to vote, hold office, and serve in a jury. And essentially, once you're off paper, unless you were committing a crime while in office, you're restored to the right to vote, hold office, and serve on a jury. I think if you're convicted of theft in office and maybe a couple of other public official related crimes, you don't get that right back to hold office again. But generally, it doesn't apply to anybody other than a handful of people that have been elected to office. So in Ohio, once you're off paper, for almost every felony, you can vote, you can hold office, and you can serve on a jury. Right? So those are automatically restored to you. So then the question becomes, when we look at the restoration clause, okay, well, I've had a restoration then. It's an automatic restoration, but it's a restoration. So then what we have from there, remember this, the way the law reads, or has had their civil rights restored should not be considered of a conviction for purposes of this chapter, comma, unless, and I'm going to say that emphatically, unless, because it's called the unless clause in the legal world, the unless clause for purposes of this act, the Gun Control Act, unless such restoration expressly provides the person may not possess firearms. So there's a body of case law around this, and it's called the unless clause. So in Ohio, as a hypothetical, again, I'm convicted of an F4 drug trafficking. I lost my gun rights, both at the state and federal level. I need to get those fixed. So under federal law, what I have to do is either get it expunged, which I could do, depending on my background, or two, go ahead and get a restoration. I go down the restoration path. I apply under state law. I get an order from the judge saying I'm restored to my gun rights. That removes, arguably, restrictions on my gun rights, because once I'm off paper in Ohio, I can vote, hold office, and serve in a jury, but I can't have a concealed carry license. So if you go through the restoration process, the argument would be that, well, because of this process, I can have a concealed carry license. Now, there's some uncertainty in the law we're not going to get into today as to whether or not that works, but let's change the facts a little bit. If you expunged your record, you very clearly have no restriction on your ability to have a concealed carry license or possess a gun in Ohio. So once that action occurs and it removes that remaining restriction, that automatic restoration works to restore your gun rights. So the restoration of rights process exists in Ohio to restore your gun rights, and hopefully at the federal level as well. So once you again have that automatic restoration, you still have to further analyze it. Is the unless clause invoked? Our whole goal in restoration for felons is to remove the invocation of that unless clause, any further restriction on gun rights, no matter how small or, in your opinion, impertinent it may be, because simply the automatic restoration may not work. So it can be complicated. I hope that made sense to everybody. I think when we go through the next the next episode, and we go over extensively the various cases, that might help. And I'm just looking at my notes here to see if I've missed anything. We've talked about unless clause and automatic restoration. There is a split in federal courts as to whether or not, when we look at where the invocation of the unless clause, again meaning unless there's further restriction on my gun rights, do we look at just the order that gave me my gun rights, or do we look at the whole body of case law? And there's a split on that. In the Sixth Circuit where I'm at, we look at the whole body of case law. That's why, when I get off paper for my F4 drug trafficking charge and I have nothing left to serve on my sentence, the law still says because I was convicted of a felony, I can't have a concealed carry license. So I have to make myself eligible for that concealed carry license to remove the invocation of the unless clause. But in some states where they just go to the court order or the certificate of final release from the prison, unless those documents specifically say there's a restriction, there is no restriction. So it just depends on the jurisdiction you find yourself in. It's a lot. I don't want to overload you guys with too much, so we're going to come back to this and discuss the cases that support this next episode. So as always, remember to be safe and carry on. Thank you.